Hello, my name is Carla Hartley. I'm the managing partner for Hartley Law Group, a multi-state law firm practicing family and probate law in Texas and California. We have attorneys that are licensed to practice in both states and attorneys that are licensed to practice in only one state. In any case in which you come to us, our goal is to make sure that we are giving you the best possible representation and advice to fulfill your needs and your family's needs in the areas of law in which we practice. Today I'll be discussing a general overview of the legal process for adopting a child regardless of the state in which you or the child are located. The first step's fairly obvious. You have to locate a child. This is tricky to me, a little bit dangerous. While many reputable firms will locate a child for you, there are many less reputable organizations involved. Our firm will not help locate a child for adoption, nor will we assist in any transaction that basically amounts to the purchase of a child or the purchase of custodial time, which is, incidentally, wildly illegal and punishable under Texas, California, and federal law. So if you haven't located a child but you want to adopt, I'd suggest considering getting involved with your local foster care agency as a foster parent, or alternatively, seeking a non-governmental agency which facilitates placement. Many Catholic charities do this. Additionally, many of your Protestant churches have relationships with homes for young women. Getting involved there can help you as well. Then we have family and friends. Many adoptions grow out of the informal surrender discussed in a prior video. This is where someone you know has a child they're just unable to care for, and they start leaving the child with you or with family or friends. We see a lot of these. This often results in relatives or grandparents, very commonly, taking guardianship or conservatorship, the title depends on your state, on the way to an adoption of the child. Sometimes the family or friends will move straight to adoption. Of course, we have step-parent adoptions as well, where you've married a mom or dad who's basically single parenting for one reason or another. That child can become your child if you meet the legal criteria and the biological parents meet the legal criteria required to free that child for adoption. Your next step is going to be filing an action to either terminate parental rights or dispense with the consent of the biological parent. In any type of adoption, once you know that you want to adopt a specific child, you're going to have to somehow terminate the rights of the biological parents. This can be done with their consent or through litigation if the legal standards for terminating a parent's rights in the specific state have been met. Adequate consent to termination of parental rights is both technical and tricky and varies from state to state. You want an experienced attorney for this. You want an experienced adoption attorney for this. I've come into too many cases afterwards where the consent to terminate was botched by an inexperienced attorney. This can cost you a lot of money, and it can in some cases cost you the child. It's better to do it right the first time, because fixing a mistake in this type of law is often difficult, if not impossible. Your third step is going to be a background check and a home study. The background check and home study can vary in both intensity and cost depending on the type of adoption. As a general rule, though there are background checks for step-parent adoptions as well as independent and agency adoptions, the investigation for step-parent adoption tends to be less costly. However, I want to be very clear here that most of these background checks and home studies are done by the social worker who is investigating for the state or for the county, depending on the type of adoption. In some cases, it may be very wise, if you are dealing with adversarial litigation to terminate parental rights, to not just rely on the social worker that the state or the county has provided to do the investigation on the background check and the home study, but it is wise to also have your own expert who can do a home study. This home study is more in-depth, it is going to be more expensive, but it has often proven to be the icing on the cake, the very last thing that's needed to set the court's mind at ease that this is exactly where this child should be. a private expert can get a lot more information for the court and spend a lot more time with you, your family, especially when the child is already placed in your home, to convince the court and to show the court that this is indeed the best possible placement for this child. It's something to consider. It's not a must. Depending on the facts of your case, it could be very advisable. The fourth step you're going to have is often going to be a trial or a hearing of some kind. A lot of times, where the biological parents do not consent to termination of the parental rights, the matter will proceed to trial. But even if you have consent, there must be a hearing. Even if the biological parents consent, you're going to have to appear in front of the court, and the court is going to have to say this consent is adequate or it's inadequate. The court will either enter it and say we can move on to adoption now, or will say this is inadequate and send you back to the drawing table, or you may even end up in a trial to terminate parental rights. The trial itself to terminate parental rights tends to be highly adversarial because you don't have consent. So you want to be making sure every step of the way from the very inception of your case that you have good representation and that you are doing everything absolutely the right way. I want to note here that when it comes to trial, the social worker doing the background check and home study will often be a witness in this adversarial proceeding. It isn't necessary per code to have them physically present in the courtroom, but it's always a good idea to have them present as a witness. You just never know in an adversarial proceeding what opposing party is going to come up with that the social worker may not have considered in their report. This is another reason to consider having your own expert, but you definitely want to have at least the social worker present in your hearing for the examination and the cross-examination, so the court can ask any questions the court deems appropriate as well. The fifth step is the adoption proceeding. This is where you can finally celebrate. This is a court appearance, but this is your big day. The big fight in an adoption is often over the termination of parental rights. That's where most of your money is spent, unless you've hired a firm to find a child, which, well, you can go check for those costs. But if the parent consents to the adoption, often rights won't be terminated until the time of the adoption itself. That's the point at which the termination of the biological parents in a consent scenario will take place. But your child is not adopted, or your adoption is not complete at the point of the other parent or both parents' termination of rights. You must have a formal adoption proceeding. So to be really clear, the first thing that happens is you have either consent or you have the hearing terminating parental rights. Neither one of those accomplishes making this child your child. That's the adoption hearing. That's your big day. That's when you bring the family and the friends and the cake and the balloons. And that's when you and your child sit down in front of the court or stand in front of the court and hear those words making you that child's parents. Thank you for spending this time with me. I hope this has been helpful. If you have any further questions or you would like more information on what we covered in today's video, please go to our website where we have many more videos for your review, or go to our YouTube page where you can also catch our videos. Thank you.